Hey everyone, it is Rob Ryder on Saturday, January 17th, 2015. I'm not sure if I've done a video yet this year. If not, Happy New Year. If I did, it must have been right at the beginning. But I wanted to start here. For those, a lot of people send me stuff and they have great ideas and they want me to read it, and there's a lot to read and I really don't have time. But I know they put a lot of time into it, and I want to show you why. You may want to think yourself of doing a video. Right? This is my, what do they call this thing? The overview page for my YouTube site. And for the last 28 days, about 22,000 views, 225,000 minutes. That works out to 156 24-hour days, 24/7 of me talking. And somebody actually listening. So if you're looking for people that may have interest in what you have to say and are actually looking in the same direction you are, that's a great way to get them. A lot of things I get sent, they're just not in the same direction I'm looking, and it's not that it couldn't be correct. I won't say that. It's just, well, I'm looking over here. You look over there. You tell me, holler if you find the berry patch, because that's what we're looking for. Just trying to find the way out. So, anyways, this is the supernatural increase you get when you put the time in, put something on YouTube. If it means something to somebody, they'll start listening to it. And, but get ready for the people that say you're nuts and crazy and you're antichrist and all the other things they may come up for you. I don't know, I had a dude on my last one that I did on taking judicial notice, saying that because I talked about a signature, I was going to get people in trouble and yada, yada, yada. It's like, dude, man, if that's the way you feel, you're in the wrong business. Turn off your computer and go work on your faith or go dig your bunker or whatever it is. Because if you're worried about what a definition of a word is and you're going to let somebody else define words for you, you're never going to get out of this. Is what I say it is. Now we're going to have to work through what you think it is and what I think it is until we can agree on what it will be. But I don't need to take your definition for anything, and as far as I'm concerned, until you say you don't agree with me, my definition is proper. Anyways, that's the problem with, words. They have lots of definitions, and that's why they did it the way they did, so that you can basically be speaking a different language using the same words. So, but enough of that. What we're here for today is gatekeeper or counter troll. How many people run into counter trolls before, right? The dead end, the wall you get to when you go to ask questions, and you get the dumb stare of somebody who's I don't know what they're I don't know if it's just because they're possessed and they don't see what they're doing, or are they drugged out and they don't see and don't care what they're doing. I don't know, but you got these counter trolls, and they saw a lot of pills at Walgreens, and I think that they must take a lot of them to do what they do daily, knowing that they're basically, well, what they're doing is denying the Holy Spirit when you get right down to it. But treating you like an animal instead of a child of God. So anyways, gatekeeper or counter troll. Or can you notice by judicial notice the gatekeeper to review judicially an ongoing legal matter that appears to be violating what he is to defend? That's what gatekeepers do, right? They defend the gate. Or Adam, he was supposed to, God told Adam to keep the garden. Adam didn't keep the garden. The devil got in the garden because Adam was scared of the devil, and then the devil seduced Eve, and Adam blames Eve for being seduced by the devil when Adam never kept the devil out in the first place. He wasn't a very good gatekeeper. So there are gatekeepers, and apparently, and they could be, you got to answer 3 questions, or who knows what it is, but at least it's a gate instead of a frickin' wall. And I'll go to the gate and take my chances with a gatekeeper. So a major part of the duty of the gatekeeper, I replaced the name of the office there. A major part of the duty of the gatekeeper is to defend the laws passed by Congress. The office generally takes the position that it will defend any act of Congress for which there is a plausible argument to be made that the statute is constitutional. And what's a statute, right? Because again, because people have lots of definitions, well, the very first definition of a statute is an act of the legislature declaring, commanding, or prohibiting something. Okay, so that being the case, then that's an act of Congress. And the dude called the gatekeeper, or as I'm calling him for the time being, is the guy that will defend acts of Congress. Well, if that's the case, then you should judicially notice the gatekeeper of acts of Congress that are being violated. That's the idea. We're going to see how that works. So I'm going to get a hold of the gatekeeper, and we'll look at what my plan is on that, and well, let's go on. So, assuming you find the gatekeeper, well, and you present something to him, well, who will he defend, the acts of Congress before? And in whose name? All interesting questions yet to be answered. And so, I am known as Rob Reiter. Court of Record, AOL.com is my email address, COURTOFRECORD at AOL.com. 616-712-6179 is my phone number, and people do call me, and, if I'm not there, at least leave a short message, but don't leave me a long one, because I'm not going to listen to it anyways. I will call you back, or I'll try to call you back, but a lot of people's numbers come up private number, right? So you need to give me your phone number. And I don't put them in a phone book, and I don't remember them for later, right? I just hit redial. If I can't find it, I can't call you back. And if you could, please donate. Please donate. That's how come I can do 225,000 minutes a month. And what people listen to is because I can take the time to put the stuff together to put out there in the first place. And that's all I do. I don't have another job. I got tired of working for the man, right? The devil. And as much as possible, I don't try to touch the stuff. But I do have to have a little. And here we are. So please, if you can, donate to the PayPal account, which is my daughter's email address, is the PayPal account name. Ashley Rytlewski, ASHLEYRYTLEWSKI, at gmail.com. Or the mailbox still works. Robert Rytlewski, 10955 14 Mile Road, Rockford, Michigan, 49341. So, what we're talking about is actually a guy called the Solicitor General. Well, let's just look at a few definitions of what a solicitor is. The solicitor is the chief law officer of a city, town, or other governmental body or department. See Solicitor General. I'll do that. In England, to become a solicitor, a person must be articled to a practicing solicitor, pass the necessary examinations conducted by the Law Society, and be admitted by the Master of Rolls. Jeepers, that sounds a lot like becoming an attorney here in America. A solicitor may practice in the bankruptcy court, county courts, petty sessions, certain proceedings in the Crown Court, most inferior courts, and also in chambers of the Supreme Court. See also barrister. But what about the Solicitor General, which, that was the common noun name of a solicitor, but Solicitor General is the name of an office. The Solicitor General of the United States is charged of representing the government in the Supreme Court. He decides what causes the government should ask the Supreme Court to review and what position the government should take in cases before the court. He supervises the preparation of the government Supreme Court briefs and other legal documents, and conducts oral arguments in the court, and argues most of the important cases himself. The Solicitor General's duties also include deciding whether the United States should appeal. In all cases, it loses before the lower courts. Well, that's all interesting, but it ain't quite enough. So, first of all, there's Solicitor General of the United States, but your state has a Solicitor General also. And he'll be under the Attorney General in the Attorney General's office. And so my first one is going to go to the State Solicitor General. But give me just a second to clean some of this stuff off of here. Okay, I won't need that anymore. What do we got here? Solicitor General. Let's read a little bit about the Solicitor General. SCOTUS for law students. Got it offline someplace. What does the Solicitor General do? That's a good question. The simplest terms, the Solicitor General is the federal government's lawyer in the Supreme Court. Lowercase federal government. That's who we want. We want the federal laws. Federal laws, lowercase federal. That's not the corporate United States of America. This is the United States. And the Solicitor General is the United States lawyer. But there is much more to the role. In particular, the job requires the Solicitor General to strike sometimes delicate balance between serving the legal interest of his superiors, the United States and the Attorney General, the long-term interest of the United States, not the United States of America, the United States, as opposed to the present administration, right? So he needs to look at the United States long-term, not just in the term he's there as the Solicitor General for a particular administration. And his responsibility as a special officer of the court himself. So he's also an officer of the court. The Solicitor General also exercises substantial authority by deciding when the federal government will appeal cases that it loses. Not only to the Supreme Court, but even from district courts to the courts of appeals, and when to file amicus briefs in these cases. And that's like, what is amicus? He's like third party or something like that. Uninvolved party. And the Attorney and the Solicitor General will often have to choose among competing views within the executive branch over what arguments to make in a case. We'll examine each of these roles in turn, but first a bit of history. Congress created the Office of Solicitor General in 1870 to consolidate the handling of government litigation in one office instead of having solicitors spread out among the different departments. And it's the solicitors that are the chief law enforcement of whatever it is. So this dude here, Solicitor General, is the chief law enforcement officer of the United States, the same being the lowercase federal government. The one that's talked about in the Constitution. So as you'll see, that's one of the things he's supposed to defend is the Constitution and the acts of Congress, because it's the Constitution that allows the acts of Congress to exist. That the Congress have the power to make needful rules. So from a tiny office, the operation has grown to about 20 lawyers. Still quite compact by government standards. The Solicitor General is appointed by the President and must be confirmed by the Senate. Yeah, that sounds like becoming a judge of the Supreme Court, basically. Appointed by the President, confirmed by the Senate. Not a lot of those offices. There are some, obviously, but his is one. And this is the interesting thing. It is the only position in the entire federal bureaucracy, including the job of Supreme Court Justice, for which there is a statutory requirement that the appointee must be learned in the law. He ain't practicing. He's learned. And so basically back in the days of Blackstone, he would have been called a sergeant at law. Or a master at the bench. I wanted to point out something else so I can get these out of here. The other thing about the solicitor, right, is get out a pen and write down the names of these two books I'm going to show you, because you may want to look at them sometime. So just, pause right now and get a piece of paper and a pen. And now that we're back, a treatise on suits and chancery. The jurisprudence of equity. Right? Equity has nothing to do with money. Equity is everything but money damages. Torts are for money. Right? Trying to get a money damage. A lot of times you don't want money, you want your property back. You want specific performance on a contract or this, that, and the other thing. So we're going to be talking equity, and the reason I point this out is because this was written for solicitors and masters. Right? So solicitors are involved in suits and chancery, which is under the jurisprudence of equity. And so this was written by a guy named Henry R. Gibson. So if you go to archive, archive.org, and you were to put in Suits and Chancery, Gibson, it'll pop up. Probably many versions of it will pop up, but this is just one of them. Okay, I just pointed out, so we're talking about solicitors. Okay, well, solicitors are in courts of, are involved in equity jurisprudence, and that's what we want, because equity, if you were to read this book, is justice. And the name of his book is called A Treatise on Suits and Chancery. Okay, and then one other one, real quick. So now, Federal Equity Procedure. A treatise on procedures in suits and equity. We had suits and chancery. Now this is suits and equity. In the circuit courts of the United States. Wherever they may be. That's what we're going to figure out. Where the heck are them places? Court rules, equity forms, English orders, and chancery. And I'm just trying to gather. And this is C.L. Bates, B-A-T-E-S. He wrote this book. Again, same place, archive.org. And all this is to show that, look, equity, chancery, and solicitors all go together. And when you're talking about federal courts, they use equity in the circuit courts. And as solicitors, well, then the Supreme Court is also a court in equity. And the Solicitor General is the one that takes cases there. So, there you go. Okay, so a couple of books that are worth, they're long books. You don't need to read the whole thing. But on the other book, in fact, I'm going to do a video. I'm just going to read some of the beginning pages because it really goes through the one from Gibson. The difference between law and equity and where common law comes from and where equity comes from. And, let's just take it from experts, the guys that were holding those offices. He was a chancellor in a court of chancery. Well, this is used in the orders in chancery here in federal court. So apparently these guys are these guys can be in chancery. They don't necessarily have to be. It depends on what hat they're in. So they could be a court of law, they could be a court of equity, or they could be a court of admiralty. Right, depending on what hat they're wearing. And so let's go back to this. Anyways, he's got to be learning the law. And this guy now, he's at 46th. Okay, there are 4 deputies, blah, 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 blah. Not too much time on this. So what does the Solicitor General do? Well, first and foremost, the Solicitor General serves the dual roles of advocate for the government and an officer of the Supreme Court. In the latter role, the Solicitor General is sometimes described as the 10th Justice, and he actually has an office in the Supreme Court building. Well, that's cozy. Good enough reason to talk to him. As an advocate for the government, so he advocates for the federal government. The Solicitor General and his staff handle governmental appeals to the Supreme Court, deciding when the government will file petitions for certiorari, seeking the court's review. And so all that is a petition or a writ of certiorari is one of the prerogative writs of the sovereign, and it's to have the lower court send that case up here to the higher court and let them review it. And that's what we need. We want, if you're involved in a court case and it ain't going your way, well, you want the higher court to review what's going on in the lower court, because we've tried all sorts of things and they don't do nothing down in the lower court. Very seldom. However, now talking about this, these taking judicial notice, which was the last video I did, and having had a couple conversations with people I've talked to in the past or gotten information from them about what had happened. Patrick out in Arizona, back in 2011, was helping his mom with a credit card case, debt collector case or whatever. Somewhere along the line, he brought up the fact of take notice of, and he quoted some act or something like that, and he went into all the things about whatever, blah blah blah. But he never really said. Now I haven't read this myself yet. I'm just going by what I was told. He never really said in what he was writing, tying together how specifically the adjudicative facts of this particular case had anything to do with the law, the act that he had quoted. Nevertheless, when they came to court the next time, the court name had changed. Same court, same place, different name. And whereas before, the attorney was showing up through a speaker on a desk, this time there's like 6 attorneys. All the attorneys of the attorney firm were now in the courtroom. And they had changed the name of the court, and it was, some little thing like changing the last word from something to precinct, or precinct to something else, or something like that. But as it turns out, there was actually like 3 different courts names that are involved in this now. So we're just starting to go through it, the light goes on. Let's look at the paperwork. That's the wonderful thing about doing these, right? Patrick's light went on and said, hey, some of what Bob's talking about happened in my mom's case. And he's down there looking at the paperwork. And look at this. We got 3 different addresses for courts. Got 3 different names for courts. We got attorneys showing up when they didn't show up before, and yada, yada, yada. Well, at the end of the day, what they did is they offered his mom a much better deal, and she took it. Right? Because we didn't know this stuff at the time. Oh, okay. Well, Mom, instead of paying $10,000, they'll take $1,500. Will you do it? Sure, I'll do that. Boom, done. Handcuffed John called me just the other day and said that he had a similar situation with his son for driving without a license, and he hasn't really explained to me how it all ties together yet. But I do remember him telling me the story. I just don't remember all the details, because I think his son spent a few days in jail, and this, that, and the other thing happened, and they finally put some paperwork in. And this time when they went to court, the prosecutor met him outside the hallway and wanted to cut a deal. And so basically his son went from spending time in jail to, quasi-house arrest at a friend of the family's for 14 days or whatever the heck it was before he could come home. And so, John said, well, he asked his son what he wanted to do. He said, yeah, I'd do that, Dad. Right? He was just tired of it, and cool. But still, John knows now. He said, man, there's something to that, and he knows that he didn't quite tie it together. So we got lots to learn over the next couple of weeks, but this is all good stuff. That's why we do what we do. So back to this guy. In the case, the court has agreed to review on the merits. The government also makes arguments in briefs and participates in oral arguments in the vast majority of cases. So we're going to try to get the Solicitor General to look at what we have to say about a case that's going on in a court below. And then they'll decide if it's time to file for a petition for certiorari, and they'll do it. So basically, we're just sending an information, if you'd like to call it that, and it'd be an information in the form of quo warranto also, as you'll see in the one that I'm trying to do, to the Solicitor General for him to go to the Supreme Court to get a writ, a certiorari, to have it brought up to the Supreme Court and to have them look at it. And if that ever happened, it'd be an all shit moment for them down below. So, as gatekeeper for the court, that's what the man does. He's the gatekeeper for the court. The Solicitor General plays a sometimes delicate and difficult role. The court relies on the Solicitor General for an honest assessment on when questions of federal law or sometimes of constitutional rights really merits the court's attention. When the Solicitor General suggests that the court deny review in a particular case, the court relies heavily on this recommendation, assuming that it means that the case is insufficiently important or meritorious rather than simply as contrary to the views of the government. And what does meritorious means? It means earning money, right? When it's strictly a case to make money, which is what most federal cases are, because there's this entity called the United States of America that is the one acting as the plaintiff against you, the defendant, like in an IRS case. But when you go read what they're putting in the wording of whatever it is they're submitting, they don't say the United States of America. They say the United States. So it's like the United States of America suing on behalf of the United States. Two different jurisdictions. And so those are meritorious. They're doing it for money, right? Give us a reward. We went out and we took care of this problem for you. Somebody's trying to steal from you, and basically that's what they're trying to say. Where in reality, they're coercing you into signing a piece of paper saying that you did something wrong. You're going to volunteer to go. In this gatekeeper role, the court will sometimes ask that the Solicitor General think about an issue of federal law. And what is federal law? Well, that's the acts of Congress. That's it is the United States Code, because it's called the United States Code, not the United States of America Code. The U.S. Code, I would say. It is executive orders. Like 4 things that make up federal law. I talked about it in another video, but I don't remember exactly what they were. But, to me, the big one is, well, it's the acts of Congress, because I can go find, and the Constitution, of course. Duh. Right? Between those two is all I need to point out that somebody's violating that act, and what are you going to do about it? Okay, so so they may write these whatever they call them, views of the Solicitor General. Okay. The influence of the Solicitor General is so substantial that private parties with cases in the Supreme Court that involve some arguable federal government interest will often ask to meet the Solicitor General and try to persuade him to file a brief on their side. Well, I'm not going to wait till it gets into court. I'm going to send it to him and see if he'll put it in their court for me, because he's dealing with private parties. The current practice of the office, however, is to almost never file uninvited amicus briefs at the certiorari stage. Right? And so during the time that you could review a case, unless you ask their office to file a brief on your behalf, they're not going to do it. By contrast, if review is granted, the Solicitor General very frequently participates in the case, both in the brief and oral argument, even when the government's interest in the case is relatively indirect. And so this is where they're going to make you an ex-rel plaintiff. They're going to sue in the name of the United States, ex-rel Robert Allen Rutluski, for violation of whatever law it is. A major part of the duty of the Solicitor General is to defend. That's who the gatekeeper is. The Solicitor General is to defend laws passed by Congress. The office generally takes the position that it will defend any act of Congress for which there is a plausible argument to be made that a statute is constitutional. Well, if it's an act of Congress, and it says enacted by Congress, whatever the enacting clause is, then it's constitutional because the Constitution said they could do it. Right? Now, someone's going to have to come and say that for whatever reason it isn't constitutional. They're going to have to defend the negative. We're going to say it is because it's an act of Congress, enacted by Congress, and that's what made it constitutional, because the Constitution gave them the right to do it. And so the Civil Rights Act of 1866, Section 2, color a law, right? That they can't use that against you. You point that out, that the court below is violating the Act of Congress of 1866, the Civil Rights Act, 1866. Well, now he has to go and defend the Act. He's not really defending you. He's defending the fact that somebody is violating the Act. That's the twist. It will not defend the constitutionality of central provisions of the Defense Marriage Act. Oh, okay. So there are certain things that they're not going to. Sometimes, though, the Solicitor General will change positions or decline to defend a statute, and on those occasions, the Supreme Court may appoint a private lawyer to defend a particular position. So I wonder if we looked at this Defense of Marriage Act, if it has the same enacting clause as, because the Congress today, they're not even taking the proper oath, or all the officers are vacated. So they really can't pass an act of Congress. That's why everything is done by executive order. Sometimes Solicitor General sometimes conclude that a ruling in its favor is incorrect, right? A favor of the United States. So, if in your past IRS case, and in fact, a brother sent me one that he wants me to look at. I think it's his wife that's been indicted for OID stuff. So we'll look at that, and that's one I'm going to use to send to the federal government. It's one of the ones I'm going to send to I'm going to send something to the Solicitor General of the United States. We'll get there. While the role is virtually invisible outside of the government, it can be contentious with the government circles. No government lawyer wants to be told that a lost case is over and will not be appealed. So the Solicitor General's decisions not to go forward may leave disgruntled feelings in other legal offices. And that's what we're going to point out. And so, right, we don't need to wait. You can see, basically, you can appeal at any time, right? So, the writ of certiorari is basically your appeal to, hey, take a look at this and see what they're doing down here in this lower court. They don't seem to be following the law. Here's what the law says, and this is what they're doing. But the work of the Solicitor General plays a critical role on the executive branch of the Supreme Court. Okay. What other one we got here? See if this one anything. Right, the United States is involved in approximately 2/3 of the cases the U.S. Supreme Court decides on the merits each year. The United States, not the United States of America. Two different jurisdictions. And the Solicitor General determines the cases the Supreme Court will review will be sought by the government, and the positions which Supreme Court review will be sought by the government, and the positions the government will take before the court. The Office of Staff Attorneys, Deputy Solicitor General, and assistants to the Solicitor General participate in preparing the petitions, briefs, other papers filed by the government into the Supreme Court. So you don't need to file in the Supreme Court. You need to file to him, and he'll file in the Supreme Court. He's got peeps. They're learned in the law. We don't need to do it. We need somebody else to do it for us. Shit. Oh, excuse my French, but somewhere in reading this stuff last week, and I didn't find it earlier, but it had talked about the thing about the writ of certiorari, writ of review, or writ of error, I guess. I don't know how many different names they could give the damn thing. That it is, because it's for review, it has to do with the supervisory capacity of the Supreme Court, because the Supreme Court is the one that has governs the practice of law within your state. Now I'm talking about your state Supreme Court, right? So your state Supreme Court governs the practice of law within your state. And by you asking for a writ of certiorari, that's asking for a review. And a review is a supervising capacity, not a judicial capacity. And therefore, they're mandated that they have to do it. Well, I've never tried it, so I'm going to find out. I think where I read that was I was just looking up writs of certiorari, and I didn't copy it when I was putting this together. But I think if you were to go read about writs of certiorari on Wikipedia, you would find something to that effect, that because it has to do with the supervisory capacity of the court, not the judicial capacity, that they're mandated, they have to review the damn case. If you're pointing out that, hey man, they're violating this act of Congress in this court case, well, yeah, they got to look at it. They got to defend the frickin' Constitution. The Solicitor General, who has an office in the Supreme Court building as well as Department of Justice headquarters, has been called the 10th Justice as a result of relationship, mutual respect, and inevitability develops between the justices and the Solicitor General. Furthermore, when the Office of the Solicitor General endorses a petition, right, so that's where it comes from. It don't come from the Attorney General. It comes from the Solicitor General who works for the Attorney General. And if you're trying to do an information in the form of quo warranto, by what authority do they bring this charge, or the fact that the municipal corporation has violated its charter, you still send it to him because he will take it to the Attorney General with his recommendation for quo warranto. So, furthermore, when the Office of the Solicitor General endorses a petition for certiorari, review is frequently granted, which is remarkable given that only 75 to 125 of the over 7,500 petitions submitted each term are granted review by the court. You don't send it to the frickin' Supreme Court. You send it to the Solicitor General. His reviews are frequently granted. Right, we just go in the wrong door, man. Go to the gatekeeper. Quit hitting the wall and go knock on the door. Most influential members of the legal community. Yeah, okay. I can see where that would be. Yeah. I don't need much more of this. When determining whether to grant certiorari in cases where the federal government is not a party, the court will sometimes request the Solicitor General to weigh in, a procedure referred to as call for the views of the Solicitor General, because somebody sent it to the court instead of sending it to the Solicitor General. So, the court can go ask the Solicitor General to take a look at it, but apparently they only, the court, 75 to 125 cases of the 7,500 petitions that they get each term, and I think there's 4 terms in a year, so we're talking 30,000 petitions. 250, 500 getting no more than 500 being granted if you go to the court. But if you go to the Solicitor General, review is frequently granted. Right? You want to get him to sign off on it. Yeah, check my hall pass. When the Supreme Court invites you, that's the equivalent of a royal command. An invitation for the Supreme Court just can't be rejected. Excellent. And the Solicitor General is going to say, hey, you ought to have them, bring this up and explain it. Traditions. During oral argument, court often used the formal, they call the Solicitor General general. We got all these general laws and general. Another tradition possibly unique in the United States is the practice of confession of error. If the government prevailed in the lower court, but the Solicitor General disagrees with the result, he or she may confess error after which the Supreme Court will vacate the lower court's ruling and send the case back for reconsideration. So you appeal your case to the Solicitor General. And they can get it reversed. So, all that was about the guy at the federal level, and I'm going to show you there's guys at the state level, but they're also at the county level. Some places. So this is, I think for Georgia it looks like. My office is committed to upholding the laws and statutes of Georgia and DeKalb County while working closely with our police and communities to develop strategies. Okay, and this was a person called the Solicitor General of DeKalb County. This Garment's the Solicitor General of Fulton County. The Solicitor General's office prosecutes misdemeanors such as simple battery, stalking, driving under the influence, in criminal trespass. So now we need to think about, okay, this is not, the higher court in your local area. This is, here in Michigan, it'd be called the district court, where you would go for these type of infractions. And so whoever is acting as the prosecutor, and I think it's going to be, here in Michigan, it's going to be called a court administrator in the district court that actually does the prosecuting. That person is the local example of a solicitor general. So, I shouldn't have to go to the federal. I shouldn't have to go to the state. I just need to go find me a frickin' solicitor general who's the top law enforcement officer and say, look, they're not doing this right. The cop didn't sign his ticket. They're not using the right version of the ticket. All the things we pointed out in videos before. So it's always the same question. Okay, we know we have the evidence. Who are we going to give it to? Now this is in Michigan. Right, this is the duties of the Solicitor General of Michigan. Habeas petitions represent the various state prison wardens in federal court actions for writs of habeas corpus filed by state prisoners claiming their federal constitutional rights were violated in the state criminal proceedings. Okay. However, it said habeas petitions. Well, a lot of times they stop. Is there more to that sentence? Is there more you could do? Can I give you my habeas petition? Have you look at it and get the Supreme Court to act on it? I don't know. Represent the State Court of Appeals. Represent the people of Michigan in the Court of Appeals and Supreme Court in appeals from felony convictions attained in counties with a population smaller than 75,000. Yeah, okay, whatever. Nevertheless, they represent the people. Opinion division. Manage the Attorney General's opinions process, drafting, reviewing, editing all formal opinions. Right? So none of that shit comes from the Attorney General. He just signs his name. It's the solicitor that's doing all the work. But here, this one I like. Serve as the Attorney General's advisor on request for the initiation of quo warranto proceedings. So just send it to this guy to start with in the opinions division. Actually, that's one way to do it. I'm going to find his address and just send it to him and have him look at it. I'm not going to send it to the opinions division. I'm going to send it to the Solicitor General of the Solicitor General's office. So, okay, so with that in mind, what are we going to use this on? Well, Jerry Stanton, who, if you've watched some of my videos, you've heard me talk about Jerry before. And, in fact, because of some of the things he sent me, I did 3 videos in a row called having to do with it's all about elections. And how these people really aren't elected. And so, for instance, H-O-N-P, William O'Grady, well, he's really not a judge. Because all judges had to be attorneys authorized to practice law. Well, if you go look at the name of the attorneys authorized to practice law, there is no P. William O'Grady. So P. William O'Grady can't be a judge. It's that simple. But this says the state of Michigan in the circuit court for the county of Branch. All in uppercase. De facto. I'd say even this is the land of color of law. And in the matter of the petition of the state treasurer for foreclosure of certain parcels of property, right? And it was given a file number, and it was filed, but it's been filed in the county clerk of Branch County's office. It wasn't filed in the court. Yet this file number is, it's really like a court number, 14-06, except for the dash. That shouldn't be there normally, but this is one jurisdiction going to another. The next jurisdiction will take the dash out and leave everything else the same. So that file number 14-06-290-CZ could just as easily be a court case as anything else. And it is a court case number of some kind, but it wasn't filed into the frickin' into the county court, circuit court. Or this file stamp would say clerk of the court. Matthew B. Hodges is the attorney, assistant attorney general, attorneys for state treasurer, Michigan Department of Attorney General, Revenue and Collection Division. Okay, well, Matthew B. Hodges, he's not an attorney either, because there is no Matthew B. Hodges. There's a Matthew, some middle name Hodges, but there is no Matthew B. Hodges, and so that name there is not authorized to practice law. So it's a person unauthorized to practice law. So we got two of them. Anyways, the petitioner state treasurer states as follows. Petitioner is the foreclosing governmental unit for this county and files this petition pursuant to the Public Act 206 as amended the General Property Tax Act. So if you were to be looking at something like this, or you have your own, and as soon as they quote whatever it is, you need to go get yourself a PDF of it and download it and do things like, well, okay, let's Google, or not Google, let's find, right? Do an edit and a find. And that little box pops up in the corner, and in there you put in foreclosing governmental unit. And you hit enter, and you see what comes up. And you'll find out, hey, it's not the state treasurer. We'll get to that in a minute. You know, the petition sets forth each parcel of property which remains unredeemed after forfeiture to the treasurer of this county on March 1st of this year, in which, if not redeemed, it will be subject to foreclosure for the unpaid taxes, interest, penalties, and fees set forth opposite each parcel of property. Okay, so I read that, and someplace I should find this list. There's the property, parcel of property, and opposite it should be a column for the unpaid tax and the interest and the penalties and the fees. The unpaid taxes, interest, penalties, fees opposite each parcel of property set forth in the petition constitute a valid lien upon the property and have remained unpaid for sufficient time but required inclusion in the petition for each parcel of property against which taxes, interest, penalties, and fees are assessed. Wherefore the petitioner asks, right? Basically, if the court steals your property and gives it to them. Okay, so this is the petition. And that generated an order, right? An order for a hearing. The state treasurer has petitioned this court for a judgment in favor of the state treasurer against each parcel of property listed in the petition for unpaid taxes, interest, penalties, and fees. Petitioner has asked the court to set a date, and they did. 2015, February 17th. In the circuit courtroom in the 15th Circuit Court, Branch County in Coldwater, Michigan, at which time person claiming interest in parcel of property set forth petition may contest the validity or correctness of forfeited unpaid. Okay, well, we're not going to wait that long. So anyways, now look at this one. This was filed into two different jurisdictions. This file here on the left is the one we saw on the other piece of paper. County Clerk, Branch County, Teresa Kubasek, all caps. In the upper left, it's Teresa Kubasek, Branch County Clerk. So that went into the Branch County Clerk and also the County Clerk, Branch County. Those would be two different jurisdictions. But neither of them are the jurisdiction of the circuit court. Where is the frickin' file for the clerk of the court? It wasn't filed with the clerk of the court. Okay, so I've shown this before, and I'm going to show it again because I just think it's the greatest thing ever. This was supposed to be the oath of office of P. William O'Grady. As you have seen, there is a guy who calls himself that, and here's where he's taken an oath of office. But again, he can't take an oath of office because for the office of 15th Circuit Court judge, Branch County, because he's not an attorney. And this wasn't subscribed by anybody. He subscribed it, but there's no notarial certificate verifying that he's the one that subscribed this, right? So this is a fraudulent document, notarial misconduct, or no notarial misconduct. It's, a counterfeit notary document. But that was what he did. So now that he's the judge, well, he did one for somebody else, and he did it for the guy that is the probate judge. And he put his seal on it. And here's that famous Michigan seal, where if you know anything about Michigan, you got two critters looking at a shield, but they're both looking in towards the center. And this one on the right is looking back over his shoulder. That's not the seal of the state of Michigan. It's a counterfeit, right? This is all simulated legal process using color of law. It looks like it's lawful, and they dress like they know what they're doing, but it's all unlawful. So Jerry sent this to me. It's like, okay, well, what are you going to do with it? And I decided I was going to write a complaint. And I would write the complaint with the idea I'm going to write it and then talk about it when I do this video, to explain how you might do something similar. Well, you don't need to go to the level I am, because I like to point out as many things as I can as a learning tool. But the idea is, right, if one thing is incorrect, the whole thing is incorrect. So you want to point out the error early and see their last. Lord Coke, 16th century, really good advice. Go to the very first thing you can find and point it out. And that would be the attorney is not the attorney that he says he is. Or what it is. Let's see. No. I want to go, not there, not there, here. Okay. So, first one I'm going to start out by calling it a notice, right? So there's no doubt that it's a notice. If you want to put in your court case, which I believe could be done also, right? That we should, because we really don't know if putting the notice into the court case is going to work yet or not, right? But it should be tried more. It's just most people won't try anything. So, I do a lot of talking, but very few people do anything. So notice, State of Michigan, take judicial notice. Solicitor General for the State of Michigan, I ask you to take judicial notice of the following adjudicated facts, points of law, violations of the Constitution, and issues of justice. Having then had your conscience enlightened, please initiate necessary actions for the issuance of prerogative writs required for swift prosecution of the offender's crimes against the people whose acts are being violated. All right, so I'm just trying to point out that, hey, I'm doing this for you, right? They're violating your Constitution, and you're supposed to defend in the name of the people. So, take judicial notice that an instrument under the heading State of Michigan claiming to be a petition for foreclosure appears to have been filed with the county clerk, Branch County, given file number, which was acted upon by one P. William O'Grady, who issued an order for hearing, filing said order into two separate clerk's offices, neither office identified with the circuit court. Take judicial notice. The alleged petition claims to be pursuant to 1893 PA 206 as amended, the General Property Tax Act is subscribed by an individual claiming to represent the state treasurer. And I don't know why I closed that. I wanted to keep it open so we could go back and forth to it. Forgive me. I may have made a mistake. Okay, so here's the petition and blah, 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 blah. We go to the last page, and who do we have? We got somebody called Patricia A. Simone, who says she's the Administrative Manager, Property Service Division, Michigan Department of Treasury, Authorized Representative of State Treasurer. Okay, but in here, of course, they never say that the state treasurer of Michigan. They just call him the state treasurer. All right. So, okay. So take judicial notice. The alleged petition claims to be pursuant to 1893 PA 206 as amended, the General Property Tax Act, is subscribed by an individual claiming to represent the state treasurer without naming the treasurer nor using the official seal of office. Because, yes, the treasurer has a seal. Where's the seal of his office? Where's his name? Right? If she's representing the treasurer, well, where's the frickin' treasurer's name? Subsequently, petition was undersigned by an individual claiming to be an assistant attorney general, not specifying the jurisdiction nor using the official seal of office. And there he is. But there's no seals on here. Right? These are our offices. The state treasurer and the attorney general have a seal. And it's that frickin' moose and elk around the shield with both of them facing in, and around the outside, somewhere in there is going to have the name of their office on there. State of Michigan and whatever office they have. Well, they're not on this paper. So that would be a simulated legal process. Take judicial notice. Neither P. William O'Grady nor Matthew B. Hodges are listed as attorneys authorized to practice law within Michigan. They and their accomplices, Patricia Seaman, Teresa Kubisic, that would be the clerk, and unknown others, are falsely representing themselves as public officers and are engaged in the unauthorized simulated legal process in violation of Act 328 of 1931, as found online, the Michigan Penal Code, Chapter 750, in particular, Sections 217 and 368. And in 217 it says, a person shall not impersonate, falsely represent himself or herself, or falsely act as a public officer or public employee, and prepare, issue, serve, execute, or otherwise act to further the operation of a legal process or unauthorized legal process that affects or purports to affect persons or property. Well, it looks like they're trying to take somebody's land. Check. You better be who you say you are. Unauthorized process means one of the following: a document simulating legal process that is prepared or issued by, on behalf of an entity that purports to represent itself to be the lawful tribunal or court, public officer, or other agency created, established, authorized, sanctioned by law that is not a lawful tribunal or a court, public officer, right? Says it is, but it isn't. A document that would otherwise be legal process, except that it was not issued or entered by, on behalf of a court or lawful tribunal. No court documents, no court seals on this paperwork, yada, yada, yada. Boom. Right? I'm saying that they have violated this act of the state of Michigan, and by God, it's his job to defend the acts of Congress, or the legislature in this case. And simulated legal process. A person or agent of a person shall not, by personal service, mail, otherwise, serve, cause to be served upon a debtor, notice, or demand of payment of money on behalf of, or creditor, of a creditor, that is not authorized by statute or court for this state, of the state, and that simulates in form and substance legal process issued out of a court of this state. Well, yeah, that's what they're doing, right? They're pretending to be a court. This dude's not a judge. He's not even a frickin' attorney. But this says state of Michigan in the circuit court for the county of Branch. Well, going up this way. And on this one, he signed it as the circuit court judge. Filed into two different jurisdictions, neither of which have anything to do with the court. Yeah, I'd say it's a simulated legal process. I would say that's pretty good evidence that they're in violation of the Michigan Penal Code, which is Act 328 of 1931. Now, not everybody has a penal code. You may have a criminal code. whatever it's called, right? If you look at it somewhere, it's going to say it's, has something to do with an act. I'm just saying point out the act as much as pointing out the statute number. I didn't mention 750-217C that way. I did say it's Chapter 750 because it is, and Section 217C because that's what it says it is. Okay, so take judicial notice. I'm not quite done with P. William O'Grady yet. A person never authorized to practice law in the state is warring with the Constitution of Michigan 1963 by claiming to be a circuit court judge. Well, that's because the Constitution of Michigan 1963, Article 6 of the judicial branch, it says in number 19, the Supreme Court, Court of Appeals, and the Circuit Court, the Probate Court, and other courts designated as such by legislature shall be courts of record, and each shall have a common seal. Justices and judges of courts of record must be persons who are licensed to practice law in this state. And the person, P. William O'Grady, is not authorized to practice law. I'm afraid he just violated the Constitution. And if he doesn't correct the problem, he's warring with the Constitution. That could be construed as treason. Take judicial notice. Petitioner State Treasurer claims to be the foreclosing governmental unit in accordance with Act 206 of 1893, whereas Section 78 of said Act defines foreclosing governmental unit as the foreclosing governmental unit means one of the following. It's either the treasurer of the county or this state, if the county has elected under some subsection to have them do it. Nowhere does Act 206 of 1893 define foreclosing governmental unit as state treasurer. This unknown other, state treasurer, a John Doe in this matter, be it an individual or an association of individuals, is an active participant in the conspiracy that uses color of law in a simulated legal process in violation of federal civil rights and antitrust acts, enacted as needful rules by the United States Congress, such as the Civil Rights Act of 1866, the Sherman Antitrust Act, as well as the United States Code. Said conspirators are now warring with the Constitution, and I believe it's your duty to defend it, the public law of the United States, as well as Michigan's laws. Take judicial notice that the petitioner claims unpaid taxes are set forth opposite each parcel of property. Paragraph 2 of the alleged petition has not provided evidence of this claim. No heading for unpaid taxes is to be found on the petitioner's, I want to change that in capital P, on the petitioner's 2014 foreclosure hearing parcel list, which basically, we got that, but he also, where was that here? They provided this list of properties, right? And so there's the county, the parcel number, the legal description, base tax, delinquent tax year, interest, right? Delinquent tax year interest. This is the interest. Forfeiture fee, forfeiture interest, publishing fee, January total tax, blah, 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 base tax. Nowhere does it say unpaid tax, right? So there is no unpaid tax. So all the rest of this is just bullshit. So there is no unpaid tax. Take judicial notice. Persons claiming to represent Branch County or County of Branch as its officers are in violation of Act 116 of 1954, Michigan election law, Chapter 10, as these actors are not registered qualified electors, where it says county officers. A person shall not be eligible to the office of county clerk, county treasurer, register of deeds, prosecuting attorney, sheriff, drain commissioner, surveyor, or coroner if the person is not a registered and qualified elector of the county in which the election is sought by the filing deadline. registered and qualified. Not just qualified, got to be registered, which requires you to fill out a registration affidavit, and unless you swear to it, an affidavit is not an affidavit. An affidavit is your oath rendered to writing, by definition. So unless you go swear to it before somebody, then, right, it's not an affidavit, so no matter what they put in front of you that says affidavit, unless you swear to it, it's not an affidavit. But they don't give you this thing called the registration affidavit. I've tried to get one. They don't seem to know what you're talking about. Further, I do not believe that they are in possession of a properly certified certificate of election in accordance with the following sections of the same act. So you want to point out the election law violations that they have. That way they never held the office. Go to the error early. Point out their last. They're not officers. Right? A county officer. Certificate of determination by Board of County Canvassers. The Board of County Canvassers shall determine which candidate for office named in Section 191 of this Act received the greatest number of votes, and shall declare such candidates to be duly elected. The said board shall forthwith make and subscribe on its statement of returns, a certificate of such determination, and deliver the same to the county clerk within 14 days following the date of election. And that's what they don't do, right? They don't. This has to be on the certificate is the wording. Needs to be subscribed on the statement of returns. The county clerk. Okay, this is certificate of election, publication of certificate of determination, and statement of votes. The county clerk shall file in his or her office and preserve the original statement and determination of the county board of canvassers of the results of the election, and shall immediately execute and cause to be delivered to the persons declared elected to the offices named in Section 200 a properly certified certificate of election. Certified by him and under or her under the seal of the county. Right? So they got to use the county seal, and it needs to be a certificate of election. And if you go down to the county clerk and ask him for this kind of stuff, I don't believe they're going to have it. They may hand you something, but when you look at what this says, it won't be in the form that they're supposed to have it in. The county clerk may cause a copy of the certificate of determination together with a statement of the votes cast at the election for the offices to be published at least one newspaper printed, circulated within the county. They have not complied with Section 204 of the same Act. Every person elected to the office named in Section 200 of this Act before entering upon the duties shall take and subscribe the oath as provided in Section 1 of Article 11 of the State Constitution, and with exception of the prosecuting attorney shall give bond in the amount and manner prescribed by law, and shall deposit said oath with the county clerk and said bond with the county treasurer. The county treasurer shall file his bond with the county clerk, but you go looking for these bonds and they don't have them. Constitutional local government offices are vacant. However, right? So because they haven't taken a proper oath, they haven't done their bond, then the office is vacant. The de jure office is vacant. There is somebody sitting there. That's called a usurper. But the office itself is vacant. Constitutional government offices are vacant. However, the office's delegated sovereign power is being usurped by unidentified actors not using the name they provided on their affidavit of identity, which was Section 558 of the same law. In Michigan, if you want to run for office, you need to fill out an affidavit of identity. Right? So now you're going to swear to your identity. If you didn't swear to your identity, well then, by God again, you weren't elected. Individuals claiming to represent Branch County, County of Branch, as the case may be, have violated any county charter given to Branch County under the Constitution of Michigan 1963, Article 7, Local Government, stole its identity, usurped its offices, are warring against the Constitution of Michigan 1963, requiring the immediate revocation of charter and active superintendent control by the Michigan Supreme Court. So, in the Constitution, it talks about the counties having a county charter. And the county that it looks like it would have been given to at the time would have been called Branch County, proper case Branch County. Well, apparently them offices have been vacated, and somebody's usurped the powers of those offices, and they're out warring with us and the Constitution. And so for that reason, that charter should be what's being violated. Right? And so this is where the writ of quo warranto comes in, and why now the Solicitor General would need to go get a writ of quo warranto to take superintending control of all the offices in the county. And then they can make everybody take the proper oath, put in the proper bond, and say, okay, right, party's over, do it right. Next time you're going to prison. Everybody gets a party foul. Offices of various municipal corporations, special taxing districts, political subdivisions, and other supposed public bodies are vacant, inhabited by usurpers. They are not qualified registered electors, enforcing unjust taxation on the real and personal property of the inhabitants of Michigan as an instrument of antitrust activity. These unjust gains and mismanagement of the wealth of the people are evidenced in the entity's comprehensive annual financial report, where you look in there and see that they got, I was looking at a school district over where Roe is in Illinois, and it had like $80 million in the bank, cash, or cash equivalent. Well, if it's equivalent to cash, it is cash. Right? What do they need that for? And then they have a provision in there that, well, what we could be doing is, staying 1 month ahead of what the proposed bills are instead of having all this money in the bank. But there's nobody in the office to say, hey, I don't think we need to do it this way anymore. Let's go to this our other option, because there's nobody holding the office, because they haven't been properly authorized to hold the office, and they get buffaloed by their attorneys. That's why everybody says, well, you need to take it to the attorney. You need to take it to the attorney. Well, that attorney that they're taking it to isn't an attorney. He's not using the name that's on his license, so he's not doing it as an attorney. He's all worshiping pagan. Been demon-possessed by the devil. He's probably a Freemason. Doesn't know that he's been demon-possessed, because if you take any oath where you say you're going to keep your brother's secrets, you've just cursed yourself, because what if he's a frickin' axe murderer? So, they join the Freemasons. Over time, they get more and more entrenched. Pictures are taken. Shit happens at parties. Underage girls get involved. Whatever they want to do. I mean, where do you think all these kids go that end up being the milk carton kids, right? They end up being people's sex slaves. Earlier this year or last year, they had all them kids coming out of Central and South America that they stopped in Arizona or something, and there was this big stink about that. I'm sure that used to happen all the time. It's just somebody put a stop to it. They were going to come up here and, be somebody's frickin' dinner. They were going to be the entertainment for this weekend's party. Crazy ass fucking people. All right, but we got to forgive them. Remember that. Must forgive. The ongoing scheme to enslave the inhabitants of Michigan includes concealing the registration affidavit form required to register as an elector, sworn to and filed by the elector, that are to be made available by the Secretary of State, who is to instruct election clerks in the proper use in accordance with Section 496 of the Michigan election law. There's no evidence of the required master file registration cards by Section 495, 501, 502 of the same Act. So I'm just quoting all these things that they haven't done. That I've done videos on all this stuff before. It's like, oh, I get a chance to actually put this on something and send it to somebody. These and other defects allow statutes to be used as instruments of fraud. Only qualified registered electors can vote sums of money to defray charges and expenses of the township. That's in the Michigan compiled laws. Non-payment results in an unconstitutional statutory lien against the government, inhabitants of township, real and personal property. So if you live in this, this lowercase township, and they're not paying the bills, because technically in the lowercase township, this is the elemental republic, the government is the people that live in that township. And so they're going to put a statutory lien against the government, which means they put a statutory lien against you as one of the people. And they're doing it by this Michigan compiled law, section 41.3, that says only the registered electors can tell the officers of the township to pay the bills. Well, there are no registered electors. They won't let you do it. Finally, provisions of the Constitution of Michigan 1963, such as Article 7, Section 7, have been declared, this is a biggie, unconstitutional under federal law. This is right in the, you print out the Constitution of Michigan, it says this. So we got Section 7 of Article 7, which is Board of Supervisors shall be established in each organized county, consisting of one member from each organized township and such representation from cities as provided by law. Then it has in the footnotes, constitutionality, section held invalid under federal constitution. Say what? Yes, section held invalid under federal constitution. Well, that would make it unconstitutional. Yes, that's the point. This section of Michigan Constitution is unconstitutional according to the federal government. And that's how we end up warring with the, being enemies of the state. Because the frickin' state has written a constitution that's invalid or against the federal constitution. So, Solicitor General for the state of Michigan, take judicial notice that you, sir, are warring with the federal government in an act of treason. And I will be bringing it to the attention of the Solicitor General of the United States for a judicial determination by its Supreme Court. Or, of course, you may have been unaware of this treasonous activity, and your immediate action now to restore life, liberty, pursuit of happiness, and security of persons will ensure that the children of God can conform the temporal order to the will of the Lord as mandated in His prayer, Thy kingdom come, Thy will be done, on earth as it is in heaven, which is a monarchy. Be of good cheer. In the holy name of Jesus, your sins are forgiven you. I declare on the penalty of perjury that, to the best of my knowledge and belief, the foregoing is true and correct. Executed on whatever day I finish this up. Robert Allen Rutluski, qualified elector, and my address, care of. So, 109, I got my address wrong. Good thing I'm doing this again. 90955. So, that's pretty much what I had to show you. So basically, going to take this here, point the things out that, they're saying that they're going to use this General Property Tax Act. But according to that act, the state treasurer is not the foreclosing governmental unit. So they're violating the act. The Solicitor General is responsible for the acts of the legislature. Well, one of his acts is being violated. He should go and investigate. By writ of, I like to say certiorari, but that isn't it. Certiorari. Writ of certiorari. And just to show you, here's the Michigan Constitution of 1963. We're going to go... There are some other interesting things about the courts. I'm not really putting in here, but... so this is for the judicial branch in the state constitution, circuit courts. The state shall be divided into judicial circuits along county lines. Okay. I had something to do with one of these I'm going to find here in a second. Okay, so then the clerk of each county organized for judicial purposes, or other officer performing the duties of such office as provided by county charter, shall be the clerk of the circuit court for that county. The clerk of each county organized for judicial purposes. Not organized as a body, corporate body politic, but organized for judicial purposes. Well, which one was that? Well, according to this, the state shall be divided into judicial circuits along county lines. And so it's these judicial circuits, like 13th Judicial Circuit, 18th Judicial Circuit, something like that, that's acting as a county. Because a county is just a defined territorial land. It's, it can be lowercase county. It isn't Kent County, a proper county. It's not county on a map called county. It's a county organized for judicial purposes. Not organized as a body politic, body corporate. Organized for judicial purposes. That's the clerk, right? So it's not this clerk that we think it is. It's not, right? It's not Teresa Kubisak, county clerk, Branch County, or Teresa Kubisak, Branch County clerk. It's whoever the clerk is of, I don't know what judicial district is, but for some reason I think it's like the 3rd Judicial District. That's the clerk. And that is probably, here in Michigan, somebody called a court administrator of a court. And like I said, in Georgia, these solicitor generals that they have are actually not in the circuit court. Here in Michigan, it would be in what we call the district court. And it was a district court chief judge that told me one time, well, it's not that you're not correct. I'm just not inclined to issue any warrants. And I had sent her some complaints, because it says to send to the district court, pointing out penal code violations, kind of like what I just did here. But I didn't swear to it. That was one of the things. And I didn't tell them to take judicial notice. And it's that judicial notice that has to do with the rules of evidence that govern proceedings within the state. And it's the exclusions that if you don't take judicial notice, they're going to exclude looking at certain things. And so you need to tell them to take judicial notice so they don't exclude looking at certain things at the beginning of the court case. So, okay. But I wanted to go... So I got to figure that. So for me, I got to figure out who this is, right? Because this is it's another level of the shit that goes on. But I wanted to show you, for some reason, where are you at? Okay. So this is local government, Article 7, local government. And there's number 7, and here's where it talks about constitutionality. I just pointed this out because you all may want to go get a PDF of your state's constitution and look for anything that says there's a section that's invalid under federal constitution, so you can say, hey, you dudes are warring with the federal constitution. And I could take this. So my idea is I'm taking this, just because of this one fact here, to the Solicitor General of the United States to say, apparently the United States or Michigan is warring with your Constitution. And get them to fix it. And I don't know if there's other sections in here that have the same thing. I just know that there's one, and that was enough. So, okay. I guess that's it. I'm going to leave it there. I don't know that I've answered anybody's questions or anything, but it's kind of how this goes. If you're in a court case, you can still tell and take judicial notice. But I'm going to try to send it to this guy because he's supposed to represent the court, and I'm going to point out that they're violating things that the court cares about. And but if we find out that you can do it in the local court, well, then we're going to do it that way because it would just be easier. If we all try to send it to the state solicitor, it won't take long. That place is buried. We just need to get the state solicitor to tell whoever's acting as the state solicitor at the more local level, this is the way you do this now. We need the Supreme Court to take superintendent control and make the people that are now usurping the offices either do the proper job or put their ass in prison. And some of them put their ass in prison and replace them. But that isn't up to me to decide. That's up for them to decide. I just need to point out the errors. That's what we're going to try to do. Okay, y'all take care. We'll see ya.